Today we're going to be talking about estate planning for singles and unmarried couples. Basically what we're going to speak about today is why have estate planning for unmarried couples, why is it critical, why is it critical for single people, how to properly title your accounts and property, will trusts, supplemental documents, retirement plans, life insurance, and if you have children, if you're single or you're unmarried, how do you handle that? Let's start with why estate planning for unmarried couples is critical. So the unmarried couple is basically two people who are together short-term, long-term, who potentially are living together or they don't have to be living together. And the question becomes, what would happen if one of you dies? Now, if you have an estate plan, then you can solve a lot of the issues that we're going to talk about. Before I get started, I think I'd like to just define for you what an estate plan is. An estate plan is how you title your assets so that they pass upon your death, how they're controlled in the event of your incapacity, how you maximize your estate and gift tax savings, and in addition to that, the people who are in charge of things, whether it's healthcare or finances or after you're gone. And we're going to talk about all those things today. Now, if you have an estate plan, then the good news is that you've designated how you want your significant other to be treated and what they should receive under your plan. What you need to know is if you do not have a plan, you don't have a will, let's say, in place, then what would happen is that your assets would pass through what we like to call intestate succession. Every state has different laws, but they're all quite similar in how they pan out. So what happens in intestate succession is there's a hierarchy of relatives who inherit your estate, which means your significant other would receive nothing. Now, perhaps that's your intention, but if it's not, you need to have a written plan in order to negate that. Also, what you need to know is without any sort of plan, then your assets are going to go through probate, which is a court process that can be lengthy and expensive, takes away a lot of the privacy, and all the assets that are owned in your individual name will pass through probate in order to move on to whomever is going to inherit. And as I said, without a will or trust, that's based on state law in intestate succession. So for instance, if you're living with someone, you are a couple, but you die and you have no plan in place, then your parents would inherit your assets. Let me rephrase. If you have children, your children would get it. If you have no children, then it would be your parents. If no parents, then your siblings, and so on and so on. If you notice in that scenario, your significant other gets nothing. So what you'd want to do is minimally have a will, which we're going to talk about what a will is in a little bit. You need to make sure that you've sat down and really allocated your assets if your significant other is going to get something, or if you've made any promises, you want to make sure that you've got it in writing what you want to do, because that significant other can later go and sue your family. So you want to be actually very careful about what you have in place and make sure you actually make a plan. Now, for single people, first of all, statistically, there's about 50% of the United States population is single. So this covers a lot of people out there. And if you die without a will, similar consequences than we talked about with the couple. If you die without a will, then your assets are going to pass by intestate succession, which means whatever the state statute says. First your children, then no children, it goes to your parents. No parents, it goes to your siblings. No siblings, it goes to your nieces and nephews. That may not be what you want, which is why you've got to have some sort of plan in place. In addition to that, if you're single but you have a significant other, that significant other may be denied access to both information and to your bedside if you're sick. A lot of people don't think about that. They assume anybody can come visit in a hospital, but what if you're in ICU and they say only family? Well, if you're not married, they're not family. Therefore, they don't have access to you. and that may not be what you would intend. So it's very important to make sure that you've put a bunch of safeguards into place, whether you're single or whether you're part of a couple but still unmarried. Let me talk a little about who the decision makers are, and then we'll talk about individual documents in a bit. Number one, you can really break things down into two main categories. Number one, financial decisions. Number two, medical decisions. With regard to financial decisions, that would be someone who is perhaps your agent in a power of attorney, a trustee, a personal representative, anyone who is able to make financial decisions for you in the event that you can't make those decisions. When we talk about the power of attorney, we're going to talk about what those agents' powers can be, but the financial decisions are half of the equation when you're dealing with any sort of estate planning. The second category is medical decisions. Medical decisions are who can make those medical decisions for you. If something happens to you, you can't communicate your medical wishes, then who's going to be making those decisions? Well, we know that under normal circumstances, the doctors and hospitals are going to look towards your next of kin, which if you're not married and have no adult children is going to be a parent or potentially a sibling. Well, that completely cuts out any significant other from the equation or anyone else you might have wanted to be making those decisions for you. If you are a couple and a non-married couple, then what you're going to want to do is you're going to want to title your assets to the best advantage. And what we want to talk about here is what situations you might have, and you may have answers for different properties. Because what we try to do, if at all possible, is to avoid probate. And I told you probate is that process with the court. It's lengthy, it's expensive, takes away a lot of your privacy. So you want to avoid probate. So the first thing you want to look at if you're an unmarried couple is what happens, what would you like to happen to the property? And this is whether it's real property, real estate, or any sort of other property, bank accounts, stocks, bonds, businesses, etc. You want to determine whether or not you want that property to go completely to your significant other, or do you want your property to be split, where if you die, you want your half to go to your family and you want your significant other's half to go to his or her family. If your intention is to split it down the middle to the two sides of the family, then what you want to do is something called tenants in common. And what that means is you each own your own interest, which means if you die, that interest does go through probate, but it's going to pass according to either your will or according to what the state statute says if you don't have a will. And then the same thing for your significant other. So you each own a separate half interest, or however you split it in terms, it doesn't have to be 50-50. You can have disproportionate ownership. That's the type of situation where if you've both put money into something and you want it to trickle down, both sides. The other alternative you might consider is joint tenants with rights of survivorship, which is where you want the property to go to the other one if they're the survivor. So it doesn't matter who put the money in. You want it to actually pass completely to the survivor and bypass the first one to die, the family. So that's an option that you have, joint with rights of survivorship. That will bypass probate. The only thing I caution you with is it goes to the survivor, but at the survivor's death, it's going to go to the survivor's issue or survivor's heirs. It's not going to go to any relatives of the first one to die. So you want to be really cautious of how you structure the ownership. And most importantly, especially if it's real estate, you want to make sure to communicate your wishes to the attorney and the title company. I've personally seen an issue where a husband and wife came to me to write wills for them, and they were married at the time. They told me they owned property. It was their homestead property, which we'll talk about briefly as well in a little bit. And then when the husband died, we probated his estate, and we left that house out of the mix because we thought it was owned by both of them as husband and wife, and therefore there would have been survivorship on it. We come to find out 2 years later, after we'd probated his estate, that the wife only owned half the property, because when they bought it, they were not married, and apparently they either didn't communicate properly with the title company and the attorney, or it just wasn't done properly. They had intended survivorship. Instead, it ended up as tenants in common, which meant there was still a 50% interest out there that had to be dealt with and reopen the probate and deal it right back out to his spouse. But if they had gotten it done properly in the first place, they would have avoided that issue. Another option you can have is to create what's called a revocable living trust. And the revocable living trust is a way of avoiding probate, of having the property owned in the trust, and the trust would then either sell the property or hold the property as an investment after you're both dead. But in the interim, the property is kept in the trust. There's a trustee or a successor trustee already named in the event of one of you becoming, or both of you becoming, incapacitated. And at the survivor's death, the property would go in through the trust however the two of you have made it, however you have named your dispositive provisions in the trust. So that's another option. I wouldn't do a joint trust for two unmarried individuals. So, it's not really the greatest option for a couple, but it could be a good option if you're a single person. Another thing you might look at when you're titling your accounts and your property, you can't do this with real property, but you can do this with personal property, is you can list beneficiaries. So for instance, if you have a bank account or a brokerage account, you can, or an IRA or life insurance, you can name a beneficiary designation, and that could be your significant other. So that way you avoid probate on that asset, but you can pass things to the significant other by the beneficiary designation. I want to talk about the home because specifically I live in Florida, and that's where I practice mostly. And in Florida we have such a thing as the homestead protection. In other states they have homestead protection too, not every state, and in most states it varies. And that's when you're talking about the exemption from creditors. But in Florida, we actually have another nuance to the homestead, and there's a couple of other states that have this, but it's very interesting. And the way this works is if you're not married and you own a home and it's considered your homestead, and you have minor children, you are actually forbidden from leaving that property to anyone but your minor children, which means you have a will, and your will says, I leave my home to my friend, my boyfriend, my mother. Essentially, that provision is null and void. The court completely ignores it because you have minor children. There is an inherent protection in Florida for your homestead for your minor children and your spouse, which makes it very interesting for people who are legally still married but have not been together for many years and are dating other people, might have other people living with them. What happens when the person dies is the spouse actually gets the property, and your significant other can be booted right out. The same thing is if there's minor children and you're living with somebody at your death, the minor children get it, probably controlled by their guardian, who will probably be their other parent, and the significant other is out on their rear. So what you got to do is you have to really pay attention to the law in your state, especially if you live in Florida, because essentially the significant other can end up homeless after the first one passes away. If you have, it's not a complicated law, but it's a pretty detailed law in terms of if you have a spouse and you have minor children. But what we're talking about today is for the single person and for the unmarried couple. So be careful of the homestead law in your state. Wills and trusts, those are the cornerstone of the documents that are involved in estate planning. The will allows you to leave your assets however you'd like, but the will governs only those assets that are individually owned and have no beneficiary listed. For instance, it's your bank account that's in your name with no payable on death beneficiary and no joint owner. That's a piece of real estate that's in your name with no joint owner on it, or it's not in a trust. So any property individually owned with no beneficiary is going to go through probate. If you have a will, you get to make the decision of where the property goes. So if you have a significant other, then you can name your significant other as a beneficiary under the will. The only people you can't cut out are a spouse, and we talked about minor children in the event of homestead. But if you do your will, you get to make those decisions. Without the will, as I talked about before, it goes through intestate succession, and it's going to pass according to state statute, first to the children, no children or grandchildren. It passes up to the parents if there's no parents, and then to your siblings. And there's a whole list of people that can inherit. If you want it any differently, you've got to put it on paper and put it in your will. The alternative to the will, if you want to avoid probate, is you do what's called a living trust or revocable living trust. It's something you can create, you can terminate, you can change it. If something changes in your life, as long as you have capacity, you can change it. What this does is any property that you put into the trust, you control as trustee. You'll be the beneficiary while you're alive, and at your death, it passes however you put it in the trust. So if you want to name your significant other as a beneficiary, whether it's all of the estate or part of it, no problem. Again, the only one you can't cut out is a spouse. So if you're not married, we're not going to have that problem. The advantage on the trust is, number one, you avoid probate. Number two, if something happens and you're incapacitated, you've got a trustee in place who can take over and handle things for you without there being an issue. And number three, when you die, you don't have to leave everything just automatically. It can stay in the trust and pay things out over time. It'll make your money last a lot longer and can protect the beneficiaries from themselves and from their creditors. And the key here is you get to name all the beneficiaries. And under a revocable trust, you can actually change it. So the will and trust are really the two main cornerstones when you're talking about estate planning. If you don't have either one of those in place, then your significant other is going to end up not getting anything. So that's what you should do when you do your estate planning. The other documents that I would do are a durable power of attorney, healthcare directive or healthcare surrogate, living will, and declaration of pre-need guardian. The durable power of attorney is where you name an agent to act on your behalf and handle any financial decisions for you. It's a very important document, but it's also a very dangerous document. You need to be really cautious about it. Depending on what state you're in, the power of attorney could be enforceable from the moment you sign it. For instance, in Florida, that's the way it is. Other states, it may not come into power until you become incapacitated. The key to the document is if you become incapacitated, you want it to be in effect. In the state of Florida, you just have to be really careful because whomever you name can technically act on your behalf from day one. There are safeguards that we put into place in terms of not actually even having that power of attorney out there. It stays inside some very safe place so nobody can get a hold of it because a copy is going to be almost as good as an original depending on who's using it. But it is an important thing because what you want to try to avoid is the fourth thing we're talking about, the declaration of pre-need guardian. You want to try to avoid guardianship at all costs, and that's guardianship of you, not guardianship of your children. What that means is if you become incapacitated, you don't have a valid power of attorney and a healthcare surrogate or a healthcare directive, then you're going to need a guardian. The court has to appoint a guardian. You have to be declared incapacitated. Some of your rights are taken away. It's very expensive. It's very cumbersome from whoever takes over as guardian. The durable power of attorney can go very far in keeping that from ever happening. Same thing with the healthcare directive. Unlike the power of attorney, the healthcare directive it's really a healthcare surrogate, I like to call it, kicks in only if you're unable to make healthcare decisions for yourself. So what you want to do is you want to have this in place so that you can name someone who's actually going to be able to make those decisions for you. You're going to name someone who you think is going to make the decisions that you would make or as closely to it. In a situation where you've got a unmarried couple or a single person, you want to make sure you name the person you want, name your significant other, because otherwise it's going to end up again where your next of kin is going to be asked to make the decisions, and the significant other may be completely excluded from decision making as well as potentially from even visiting you at your bedside. So if that's not the way you're intending things to be, you need to have all those things in writing. It also puts your family on notice of who you want to make decisions for you. Hopefully it, causes less drama if you've put it all on paper. Same thing with your power of attorney. If you want your significant other to be able to handle financial stuff for you because you're living together and doing a lot of things jointly together, then you have to have that on your power of attorney, because otherwise they'll have absolutely no rights to do anything. Now, most people do a living will. The living will is a document that says that if you're unable to communicate and the only way you're going to be kept alive is to be kept artificially alive, or for life-prolonging measures to be taken when they're not going to really do anything for you, you can have this living will which actually expresses your intentions regarding that. What I like about the living will is it actually puts your family and your friends and anybody close to you on notice of what you would want. So that means it relieves a little bit of the emotional responsibility from them, because they won't necessarily have to make the decision of whether or not you wanted the ventilator to be removed or no treatment done if you're vegetative and you get an infection. You're taking away that responsibility from them. Ultimately, obviously, they'll probably have to sign off on it, but it's not really them initiating that decision, and it does make it a little bit easier, even though obviously it's an extremely traumatic event. There are actually religious issues with living wills, so if you come from a religion where there's beliefs that will contradict the living will, you want to have that in mind when you're talking to your attorney about doing it, because that could play a significant role. Whether you're Jewish or a Jehovah's Witness, those are two that I can think of off the bat, which have actual situations where you need to modify the living will, or at least consider modifying the living will. And then lastly, here on the supplemental documents is the declaration of pre-need guardian. I talked about guardianship. That's if you're incompetent, you can't make decisions for yourself. You can't really make life decisions, daily decisions, financial decisions. Any one of those can trigger the need for a guardian. We want to avoid it, but if we can't avoid it, what we want to do is at least put in place something that says whom we want as our guardian. So if you're in a relationship, you probably want your significant other to be your guardian, although you may not. So you want to make sure, put it in place so that if you should need a guardian, that can be submitted to the court, and the court will know who your first choice is. One thing I didn't put on this list is a HIPAA release, which is actually really critical. Anytime we go to the doctor, we know we have to sign some sort of form about HIPAA and privacy. If you want your significant other or anyone else to get any medical, educational information about you in order to help you, for instance, they need to get you medical care, they need to be able to access your records, then they need to be listed on a HIPAA release in order for them to have access to those records. Some tips for the unmarried couple. Number one, you want to keep things separate, and I'm talking assets and liabilities. Don't have a joint credit card. Unless you really feel the relationship is very solid and it's a forever thing, then you probably don't want to combine your assets unless you're both contributing equally and you have it owned in some sort of tenant in common situation. You want to consult an attorney before you buy any sort of home or real estate. especially in a homestead state, because we talked about what would happen, the limitations on homestead. Now keep in mind, two unmarried individuals can each carry homestead on the same property, but it's going to be a nightmare when one of them dies unless everyone is in agreement that the survivor gets to keep the property. Otherwise, they might be forced to sell it because the other half is not homesteaded anymore. So you want to keep that in mind anytime you're buying a piece of property. You can consider a cohabitation agreement. It's not really a valid agreement in every state, but it's really a way of putting down on paper what each person's responsibilities are. So who's paying the mortgage? What are you contributing to? What happens if you do own joint property and one of you dies? Those are all things that you can just really put in writing. So it's not a bad idea to have one of those things. And finally, if you do decide to get married, which I'm not advocating yes or no, but if you decide to get married, you want to do a prenuptial agreement. And the prenuptial agreement will specify, what I came into the marriage with is mine, what you came into with is yours. Here's what happens if we own jointly held property. Here's what happens, if I die. It does not prevent you from leaving anything to your to your spouse at that point when you die, but it does make it a lot easier if, you end up getting divorced. And since I believe the divorce rate is definitely over 50% in America, which accounts for why we have a single population of over 50%, it's definitely something I would recommend. And you do not want to do it yourself. There's a lot of rules and regulations with attorneys having to be involved, individual attorneys for both the future husband and the future wife. Some other things you need to consider as part of your estate planning if you're single or you're in a couple relationship is your retirement. Now, your retirement generally comes with where you can pick a beneficiary. So you want to put the beneficiary that you think is the best choice on your retirement. There is no requirement if you're not married for you to leave your retirement plan to anyone specific. So keep that in mind, but always list that beneficiary designation, because if you don't have a beneficiary designation, then it does go through your will or through, if you have no will, through intestate succession, so it may not pass the way you would want it to be. There are restrictions in terms of rolling over IRAs. Sometimes a non-spouse beneficiary is not able to roll over the assets, but you need to make sure that you check this out and review it, every couple of years at least with whoever's handling your IRA, whoever the administrator is or your financial advisor if they're the ones handling your IRA. Don't ever forget about beneficiaries because it's one of the biggest mistakes people make. Also, if somebody should pass away who's a beneficiary, you want to revisit all your beneficiary designations. Same goes for life insurance. I'll repeat about the beneficiaries. Always keep track of who your beneficiaries are. If you're not married, it's a pretty important thing to have life insurance on the other person. Either you own it or they own it, but it's a way of passing liquid money to them in the event of your death, potentially so that they can pay off joint property that you own. There's a lot of reasons for it, but it gives the liquidity. Life insurance is the best source of liquidity at death. Also, because if you're not married, your spouse is not legally entitled to a part of your estate if you don't leave it for them. So they have no rights that they can enforce against other potential beneficiaries fighting your family. If you leave them the life insurance, then it should alleviate a lot of those problems. So you want each other potentially as beneficiaries. Use life insurance as part of your plan. Keep in mind that when there's no spousal relationship, the significant other does not inherit the Social Security of the one that passes away, and corporate pension. So it's a way of supplementing those funds that were coming into the household. For instance, if you're the one who's supporting the household and your significant other doesn't really have an income, well, what happens if you die? Who's to support them? So this is a way that you can actually safeguard that situation. A life insurance trust is a special type of trust if your estate is higher than the exemption amount, which is currently at $5.43 million, and that's the subject of another webinar. Then if you do have life insurance, it just increases that estate and could cause an estate tax. So there's a way of doing it in an irrevocable life insurance trust where you can have the life insurance in the trust, it stays out of your estate, but can still pay out to whomever your beneficiaries are. Lastly, I want to talk about children. Now, we'll talk about children in two different concepts. Number one, if you're an unmarried couple but you share a child, then you want to make sure that you've provided for the child in both estates. So both parents should have some sort of provision for the children in their estates. You potentially want to have life insurance to make sure that the kid's education can be paid for. You don't have the same thing that you would have in a divorce. Very often in a divorce, there's life insurance to compensate for one of the spouses or former spouses dying, to cover any sort of expenses of raising the child, of education, and things of that nature. And that's usually forced by the court during a divorce. If you're unmarried and you've never had to go through that process, you may not consider that. There might be, if you weren't the one working and you were raising the children, what's going to happen if the other one dies? You have no right against their estate because you weren't married, and if they left everything to somebody else and not to their children, or they didn't have a will, then you and the children could be out of luck with no place to live, maybe if there wasn't a homestead, and with no means of support. So, you want to consider, keeping those children in mind throughout the process. You want to think about how your children are actually going to get the money. If they're under 18, then if you leave them anything, it has to go through a guardianship, and then at 18, they get to keep it. Not a good plan. Most kids at 18 are still in high school. We don't really want them getting any money. So you might want to consider using a trust in order to portion out the money as needed to pay for their care, health, education, maintenance, and support, and whatever else you want to leave for them. And you can make your significant other as a beneficiary or not. And if you're single and you don't have a significant other, the key for you in that situation is who are you naming as their guardian and who are you naming as the trustee to handle all that money. I like the trust, especially when you have kids, because it does provide a lot of flexibility with the kids. You also want to include your unmarried partner in your plan for the trust if you're going to need to continue to support them. And finally, let's talk about guardianship of the children. We just mentioned what guardianship is. Guardianship is who is going to care for the children. That would be what we call guardianship of the person. Or the guardian of the property is who handles their money. Now that would be money that we haven't left in trust. Both of those are governed by the court. So what that means is somebody has to be appointed by the court. It's a very lengthy process. It's a very involved process. That person is entrusted to, if they're guardian of the person, to the care and needs of your child. And if they're guardian of the property, they're entrusted with the money, all subject to court approval, which means if they're dealing with the money, they don't get to make any decisions without court approval. Each time they want to do something, they've got to go into the court, get an attorney, and it costs money, it takes time, it's extremely restrictive, and the worst thing is that at 18 it's all over and the child can stick out their hand and say, I'd like the money now, and you're bound to give it to them. So I like to avoid guardianship at all, guardianship of the property funds at all costs by doing trusts. But if you don't have a trust in place, then the guardianship of the property is going to have to be there. So the key is who's going to be the guardian of the property. If you're single and divorced and you aren't particularly fond of the other parent, and you don't think they'd be a good choice for handling the money for your child, which is generally the case, then what you want to do is you want to make sure to name somebody else in your documents as guardian of the property of your children. This would hopefully, now the court is not bound by your decisions, but it would hopefully allow the court to appoint whomever you want to be in charge of your kid's money. You can't take away a natural parent's right to be guardian of the person and raise the child, unless, of course, their rights have been terminated. But you and your documents can't take that away. No matter what you put in there, it won't matter. They're still going to have the care and custody of the children. So if you want them not to have immediate access to money, you've got to deal with that by creating a trust or naming a guardian of the person other than them. Lastly, what you want to do is, while you're alive, if you have anybody who actually has care of your child, whether it's your significant other, whether it's your nanny, whether it's your parent or a sibling who spends a lot of time with your children, you want to make sure to do a medical power of attorney so that you give them the right to go take that child to the doctor in the hospital to get them medical care and be able to make medical decisions. Generally, they're not going to be refused care. However, it does create a delay in getting certain things done if there's no one who has the authority to make decisions. So don't put your children in that position. I always like to do the medical power of attorney for the kids. I always say attach a copy of the insurance card, your driver's license, so if they need to register the child at any medical facility, they'll be able to do it and, keep down the problems that it's going to cause.